Welcome, everyone, to the Money Mindset Mastery Podcast. I'm your host, Jim. Joining me today, I have both Eric and Denis, fresh from a trip out in beautiful Paris. Is that where you were?
In France, not Paris, but
Not Paris?
right
All
near
right.
Marseille, but it was good.
All right. Well, welcome back. And Eric, you're getting your tech stuff all sorted. That's why, sorry, we're a little bit late right now. Eric is the new Ryan for today.
Can't wait.
And Ryan's not joining us because his train was late. Today, I want to talk about a topic that's come up a lot, actually, personally in my life. And I don't know, Eric and Denis, about yours. But the topic is the family money conversation no one has until, sadly, someone dies. This is something that I've been personally dealing with. I had, for example, my stepdad passed away in early January, and that kind of prompted us to have more of a deeper conversation surrounding my mom and her situation. And my father-in-law, he's turning 89. We're starting to deal with some health challenges. Honestly, it should have been something we probably should have talked about in more detail before, but there's many reasons why people don't like to talk about these things. And we're going to get into that a little later on in the recording. So I'm going to share with you one scenario. Picture this. A father passes away unexpectedly. His kids assume that there's a will, there's a plan, and that there's something that's organized. But instead, what do they find? They find a box of papers, a rental property that no one understands, a corporation with retained earnings, and a $600,000 tax bill due in months. No one knows where the insurance is or if he even has insurance. Sound familiar? Like, this is just one type of example. So we're going to try to get into what this really ultimately means and why we really need to start having conversations with our loved ones when it talks about what would happen or what will happen when they ultimately do pass away. Some stats for you guys. The first one is right now there's $1 trillion transferring in Canada from one generation to the next. And yet 54% don't even have an estate plan. So that's alarming to me. It's not really maybe surprising because when I'm dealing with new clients and I ask them if they have an estate plan, I would say probably it's about 50-50, where 50% say they do and 50% say they don't. Denis, you are a trust and estate practitioner. That's a designation that you have. How do you feel that there's all this money that's transferring and 54% of people don't have an estate plan? Why do you think that is?
One thing is the conversations are not happening.
Right.
So that's the first thing. After that, it's the conversations. They need to know what they'll be getting, your beneficiaries, and how it'll take place, especially on property. When it's owned by the parents only and the second parent dies, how is that going to be done? Sadly, in a lot of cases, not all the siblings get along. Not all the siblings would want the property. They just want the money. Who wants it, first of all? And if nobody wants it, then it's easy. You just sell it. But if somebody wants it, then it changes everything. And I've heard some cases where this is happening, two live in Ontario, one lives in BC. Well, do you think the guy in BC wants anything to do with the Ontario property? No, they want the cash. So there has to be a plan to somehow buy this person out, whether it's through insurance or, depending on how liquid the estate is, cash. And equalize is another case in itself. Not every estate plan or will can, needs to be equal to all the beneficiaries, even if they are siblings.
Right.
Some are more involved, some are less involved, some are estranged. I hear a lot that it's split evenly between the kids. It doesn't have to be that way.
Right.
And it doesn't have to be in the same way if you're going to equalize. It's not 1/3 of everything you own. It could be mix and match.
Eric, 52% of parents haven't even discussed inheritance.
Yeah.
That's crazy.
Denis was talking about the 50-50 or split three ways or split evenly. A lot of times there's one child that will put a lot of effort into the property. And so the problem with not talking about it is you get to the point where the parents are now gone. So their reasoning as to why they set it up this way or why they'd like it this way has changed. It just 52% leaves such a huge opening for misunderstandings, for misalignment of goals, for not really knowing what mom and dad wanted if they're not there to help clarify that. And it just leaves a huge gap that can create that rift, because really that's what it comes down to. kind of work through the issues of what things look like while everyone's still there and can put it together in a way that makes sense? Or do you want to leave it to possibly be a bomb that goes off that upsets the family dynamic? And that's really the big risk. Having those clarifications made while you can understand why the parent wants it that way, and just clears up so much potential for strife and disagreement and problems.
Yeah. And so again, 54% don't have an estate plan. 52% of parents haven't even discussed the inheritance. And yet 67% of younger Canadians want that conversation. So it's amazing because, again, even if I look in my practice, when I do talk to a lot of my older clients, they are asking for advice on potentially on how to handle things, but they're not really having those conversations with their kids, right? But when I'm dealing with the younger clients, they're asking me about that transition and what could we do to kind of make that transition a lot easier for themselves because they know that they're the ones that are going to have to deal with it. And trust me, there's a lot of work involved. Again, I just recently dealt with a very small estate, and it took a lot of work to handle that. Larger estates, more assets, bigger assets, obviously a lot more work behind it. So what I do want to say is this: in this episode, we're not talking really about death itself. We're talking about control, right? And whether your family's prepared or forced to figure it out at the worst possible time. I remember I had one person in the industry years ago ask the question, how far out of the coffin do you want your arm to be? Right, to extend out in terms of control on what happens with those assets and how they get distributed. So that's really what we're going to be talking about today, more so is about control and making sure that things are handled properly. Now, I have talked to people who avoid the conversation. When I ask them about insurance, estate planning, putting wills and powers of attorneys, and the response they give me is, I don't want to talk about that because it'll lead to my death. Denis, do you think that's true?
No, they may not be easy conversations,
Right.
but no, it shouldn't lead to your death.
Right.
There may be arguments, there may be complications. And we mentioned second property, but what about if you're one of the siblings now living with the parent and their only property and could be the biggest asset? If there's no plan in place, what happens with the other siblings not living there?
Yeah. Now, some of it can be cultural, right? There are some cultures where they just don't talk about money, and that is very cultural in nature. But, in saying all that, I do want to reach out to the individuals who are watching and listening where this might be cultural. If you don't address this properly, there's going to be a lot of money potentially given to the government for no reason. So you've worked really, really hard to build all these assets, and it's just going to go to the government, or it's going to just drag on, drag on, drag on. And like you said, Denis, potentially cause a lot of issues among siblings. I know I've had some clients in the past where there's a cultural reason why they don't have the conversations, and they'll say things like, my kids get along, they all love each other. Everything will be split equally. And then when they do pass away, emotion comes into play. So some people handle the loss of a parent in a different way than others do. So there's the emotional aspect behind it, but also there's partners, spouses, that sometimes they come into play as well and cause a bit of an issue. So always better to write things down, write what your wishes are, so that way they can get carried through. Another one here is I don't want to create any form of entitlement. Eric, can you talk about that a little bit?
Yeah, whenever an estate ends up being divvied up in a way that's not completely straightforward. I saw a friend of a client, their family went through a really interesting scenario that I think illustrates this perfectly. The kids had pretty much abandoned the farm. They all moved into the city, had no interest in it. And for about 35 years, there was a farmhand that stayed there and, made like almost minimum wage, spent his whole life pretty much dedicated to keeping that farm running. And his parents left a big chunk of this to the farmhand. And it was interesting because the kids didn't know this. When everything came to light, because of the lack of communication, it turned into a big lawsuit. Again, lawyers walked away with most of the value. And had the parents said, look, if you want some entitlement to the family farm, well, then you've got to put some time in, come out at harvest time and help out. And it could have been a completely different scenario had the kids known. And again, by the time it was all said and done, I think the kids got a little bit more than what they would have had they not done anything, but the vast majority of it went to lawyers. And it's that sense of entitlement. If you don't discuss what you want to happen as a parent, then really it leaves the door open for people to feel whatever it is they want to feel about whatever they think they might be owed or whatever they think they might deserve. And so entitlement is a very powerful, entitlement can destroy an estate that could have been relatively simple had the planning been done beforehand.
Sometimes it's easier to just have one child and that's it. Right.
Yeah, I think some say no children is probably the easiest, but
Right, exactly. Yeah, but again, we talked about emotion. Some of it is fear of aging. That's a real fear and concern. Loss of control obviously is another one, and family dynamics. I know we've recently worked on a file. Ryan actually did, where they're siblings, and one of them has a bit of an issue with drugs, and they wanted to make sure that things were split in an equal fashion, but concerned about giving the one sibling a bunch of money because that could potentially be a bigger issue for that sibling. You can create trusts to kind of control the distribution. You could put money into an annuity to kind of control the income that's being paid out. So there's different ways around it. So sometimes it is just dynamics. One may be a gambler and the other one might be a business owner and very responsible. You just don't know, right? And for someone to all of a sudden come into a lot of money like that is very similar to someone winning the lottery. And there's a reason why 80% of lottery winners after 5 years are actually worse off financially than when they first started. So think of it in a similar way. Like when someone's receiving an inheritance, depending on the size of the estate, it is like a lottery winning in many cases. So think about that. 80% of lottery winners after the fifth year are worse off financially than they were before they won the lottery. That could be your family after you leave an inheritance to them, right? Rising costs of living. So 80% of parents now unsure they can even leave what they plan to leave. That's another concern. I mean, depending on how much you have in terms of assets, that is a concern where they think that, okay, well, there's X amount that I've set aside. That's part of my estate plan. That's going to my kids, maybe even grandkids. And then they realize, oh, I might not even have enough to kind of live the rest of my life, depending on how long they live. They can outlive their money. If there's mobility issues and all of a sudden they're in a facility care home, I've heard things like people who have 24-hour care for Alzheimer's, as an example. Look, we're looking at $10,000 to $12,000 a month. And again, the real risk, decisions get made under stress. So when you're dealing with someone, well, I would say even in my family with the dementia side of things, you need to sort this out before they get to the point where they can no longer make decisions. And we probably should have had Sonia in on this meeting as well, because once you have dementia or Alzheimer's, that's it. There's nothing you can really do. It's ultimately left to the courts after the fact, and that can become quite costly as well.
yeah, there's a situation kind of in my family that's in a similar spot right now where there's a family member whose memory is starting to go, and so the conversations are being had, I think, ahead of it enough that it's going to be all right. But a year from now, maybe the situation would be bad enough that you can no longer have that person participate in that conversation. And then who takes responsibility? Who covers the costs of the dementia care if their spouse is in a position where they can't? I think you said it, Jim, that the real risk is decisions getting made when there's a lot of other stressors now and factors in, and not everyone who you want to participate can, whether it's because of dementia or death. And that's really where people will start to have problems to say, well, no, I talked to mom once and she said X. And the other person says, well, I talked to mom once and she said Y. And
Yeah.
maybe X and Y were the same things understood differently. But when you don't have that person there to say, let me clarify, the stress of having to make decisions when you don't have the people who really wanted to be involved in making those decisions, that's the real risk is you have to make those decisions with only part of the facts, part of the people involved who it affects. Having those conversations are tough, but it's way better to have them while you still have everyone who's involved there to participate.
Yeah, we're gonna continue on to the next topic, what actually happens when you die. But to kind of finish off our conversation on this topic right now, what I would say is start having the conversation not separately, right? Have a team meeting, or not team meeting. Say team meeting because this is what we have every single week as advisors. Have a family meeting. Be very specific about the family meeting, saying we're going to book a family meeting, bring the KFC and whatever else, the McCain chocolate cakes, and we're just going to talk about the next stage. Try to find out what does everybody want, what everybody like, just to kind of air it out there. Now, it could be emotional. It could cause some friction. Better to get it out while you're alive than after the fact, right? When the actual death causes a lot of that stress. So that's something that I would encourage anyone who's starting to plan their estate is to have that conversation as a family meeting. And then after you do that, that's when you should take it and meet up with a lawyer and write it all down. Things like who's the executor. Here's one example. We had one family, all three siblings were named as executors. The reason why is because there could potentially have been some jealousy amongst the siblings. So they didn't want to name one or two and someone else being left out. They wanted all three of them to be named as the executors. One of them lived out of the country. So anytime anything needed to be signed by the executors, they all had to be present in the country to do so. And that just ultimately delayed things. Now, if you want to name three executors, like for example, in my family with my siblings, we're going to have the three of us as executors on my mom's estate, but we've decided that it's going to be any one of us three can sign off, as opposed to all three of us need to sign off. Or you could do it, two of three can sign off, as opposed to all three. So these are things that people don't think about until they're dealing with it. And then all of a sudden it's like, gosh, this isn't great. We have my father-in-law who lives in Alberta. Once again, like I'm praying that he set up things properly with his will, because if he set it up that a whole bunch of people are going to be listed as executors, none of his kids actually live in Alberta. They're all across the country. So those are things you really need to start talking about. And the executor's role, and most people don't understand this, it's their responsibility to basically close out the estate. So maybe did you talk a little bit more about the executor's role?
Well, I think they're going to be the captain to deal with everything.
Yeah, that's a good point.
Financial, not only assets, but paying off debt as well. I think people always forget the other side of the ledger. You distribute assets, but first you got to pay off debt. If not, the executor will be responsible for paying it off himself, him
Yeah.
or herself.
Yeah.
So you got to look at both sides of it. The first thing they do is actually organize the funeral and start paying for that a little bit. First of all, the executor has to know he's been chosen for an executor. So if they don't touch anything, then they could walk away from it. But if they start playing with it, they can't walk away with it anymore. Then a formal process has to take place. So you start gathering the information. You make sure all the beneficiaries are known and whereabouts and address and everything else. That could happen, change. Estranged families, people move a lot. The executor doesn't know the kids and don't know where they live. You are the one that's responsible for everything. And in a lot of cases, legally liable. Hopefully it was a will and estate plan that's very clear. If not, it opens up to litigation. Once you got everything gathered, you got to apply for probate.
Mm-hmm.
So you apply for probate, start that process. You don't distribute assets. Sometimes people want it within a couple months. They want the money. You got to figure out everything first and how much is owed by the state. And if the ones who passed away, did anybody owe him or her money?
Yeah.
Everything has to be gathered. Or did he owe somebody money?
Yeah.
And for sort of in the formal loan to a neighbor.
Well, let's talk about probate here for 1 second, because the one area that people don't really quite understand is, for example, a principal residence, where it's like, okay, there's a principal residence worth $1 million. Great, we're going to sell it and get our money out tax-free. It's like, no, hold on. In Southern Ontario, that asset has to go through probate. Right now, it's about 6 to 9 months to go through the probate process in Southern Ontario, which means, let's assume it's 9 months. That home, you can't sell that house. You can't even list it until the probate process is completed. So for 9 months, there's nothing you can do, but someone has to still service it and maintain it and whatever else. And then after probate is completed and the fees are all paid, then you can go ahead and list it. And again, this is the executor's responsibility. So then they're going to have to list it. clean it out, do whatever else. So on a principal residence, it can take anywhere from 10 to 24 months to actually sell and complete the process, right? So being an executor isn't an easy job. Ryan is contributing here. Roughly 40% of executives were unaware that they were assigned, appointed as executor until the person passing. Ryan, that's a really good point. Once again, anything we're talking about today isn't to be considered financial advice, legal advice, estate planning advice. So if you are looking for specific estate planning advice, you can reach out to Sonia at TVH Legal. She can assist you with working through your estate plan. But let's talk about the executor role a little bit more, Denis and Eric. So I think as the person setting up their estate, they should be very careful who they assign or request to be their executor. But if you are being asked to be an executor, and I know I've had a lot of people say, oh yeah, I was asked and not a problem. First, really fully understand what you're getting yourself into before you ultimately agree to that responsibility. Because like you said, Denis, it's a huge responsibility. And there could be a debt liability that if the executor didn't distribute things properly, it's the executor's personal responsibility to address that debt or taxes.
Yeah,
Right?
and back to the fees, you got to maintain that house completely. Insurance paid, bills are paid,
Yeah.
everything.
Yeah.
And somebody you may have thought was a great executor when you did your will, which could have been 20 plus years ago,
Yeah.
may not be the person to deal with it 20 years later.
Or you named that executor 20 years ago, they passed away, and you
Yeah.
didn't change your will, right?
Yeah.
So these are things, again, you really have to start thinking about, and these aren't things that we're making up. These are situations that we've come across throughout the years of being in business, and it's difficult to draft together a perfect will and estate plan, but that's the reason why you should be reevaluating every couple of years to make sure that everything is properly lined up, right?
Yeah, not only the executor, but the power of attorneys as well need to make sure that it's still current.
Yeah.
They still can do the job and they're ready to do the job. Always got to be reviewed on a regular basis, at least every 5 years, and with every life event that will affect your will.
But even that point, Denis, like power of attorney, people don't understand the difference between a power of attorney and an executor. So I've had people say, well, my power of attorney is taken over the estate. It's like, no. The power of attorney is active when the individual is alive. Once the individual is deceased, that's when the executor steps in. And many cases, the executor named has been different than the power of attorney, right? But people do misunderstand the roles between the two. So just as a reminder, power of attorney is for people who are alive, executors for when people have passed away and there is now an estate. Okay. So let's kind of talk a little bit more about what actually happens when you die. And we're not talking about spiritually or anything like that. We're talking about financially and how CRA views things, because that's a whole another podcast episode. The first thing, like you said, Denis, there's a deemed disposition right away, right? So the moment you pass away, CRA is going to treat it as if you cashed out everything that you owned the day before you died, right? So that applies to your RSPs or any registered accounts. That applies to your home, business, rental properties, like everything. What's the problem with that?
That's a pretty big tax year for some people, especially if you have a big RSP or LIRA or registered accounts.
Right.
Yeah.
Right.
Yeah, if you have a spouse, that's a little different. You have the spousal rollover for almost everything.
Yeah.
So when that happens, it's different. But if you're the last one to survive, or you're single, whatever case the case may be, it becomes a lot more complicated and very expensive on the tax wise if you have that big RSP or you have some asset that has a huge capital gain on it.
Well, how many times have you seen an RSP statement from the bank or from one of the online investment firms, and the estate is listed as the beneficiary because the person wasn't given the advice to say, well, you have a spouse, you should name the spouse, right? And if it's not listed in the will, then again, that's actually potentially a taxable event. So this is where advice really is important. I've seen it in group plans where it's just, you've been married for 10 years, but I see your mom listed here as a beneficiary. How come? Oh, well, I set that up when I first opened up the plan. I'm like, do you understand the tax liability that'll happen because that beneficiary hasn't been changed. If you have a spouse and you don't name them as the beneficiary for a spousal rollover, we'll use a $200,000 RSP portfolio. CRA is going to basically state that you cashed out the entire $200,000 the day before you died, which means you're going to have $200,000 of earned income plus any other income that you've earned that year, which means about half of that RSP, you can kiss it away to taxes. Where if you did things properly and you named your beneficiary, you could have then rolled it over tax-free to them. There wouldn't be a tax event until they passed away. People don't understand this as well sometimes is with businesses, commercial properties, if you have it in a single spousal name and you didn't designate your surviving spouse as the beneficiary, right? That spousal rollover doesn't happen. There's a huge tax liability. So make sure that you structure that properly.
Ryan also brought up the point that a lot of times on older accounts, their ex-spouse will be named. And again, if they're not your active spouse, then that is a taxable event.
Right. Yeah, I feel like the ghost of Ryan is kind of stepping in here.
It is.
All righty. Probate. We talked a little bit about probate. For example, Alberta's quite minimal, about $525, right? But in Ontario, it can exceed over $14,000 on a $1 million estate. And there's ways that potentially you can kind of avoid paying that. But probate is not the main tax problem, right? It's registered accounts. It is non-registered accounts not structured properly. And there's a major misconception. 62% of people think that a will avoids taxes. That's not what the will's for. It's not tax planning.
It sort of straightens out who pays the tax for the most part. And we mentioned the executor before. That person would be in charge of filing those last death tax, final tax return. But no, it's probate fees you can't get around for the most part. Ontario, I think the first $50,000 is free, but after that, you are paying. The will is just a way to split your assets after you pass away. There's a lot of gifting while living now, so a lot of people are doing it at gifting while living where it doesn't have to take place after the fact. Whether it's that first property, that second property, especially when you go into a retirement home, the property's already sold and it goes into, investments or cash. And that's when you could start your gifting while living, especially when it comes to collections or something that only one child really likes or one beneficiary is preferred to have. Give it while you're still living.
The one thing that I caution them with is you might need this money down the road. Again, potentially you might outlive it. You might live a lot longer than you expected. Or you might have health issues and you're going to need some higher expensive care. And, the concern that I have with gifting, and I've seen this in the past, parents have gifted money to their kids. The kids then take that money and pay down their mortgage. And then 5 years later, the parents are like, actually, we kind of need some of that money back, but they can't get the money back out of the mortgage, or that child has gone through a divorce and now it's turned into matrimonial assets and half of it went to the divorce. So it's not a bad strategy to gift or to potentially trigger that tax while you're alive, kind of pay that tax it's dealt with, and then you kind of gift whatever the property or the investment is. But just keep in mind that there are other risks associated with that gifting strategy as well.
Yeah, the calculations have to be made. If that were the case, what if they need extended care? How much would that be? There's still enough. You got to make those calculations to make sure the parent's still in the position where they can pay their own way in a retirement home, no matter what care they need.
Right. Right.
And that kind of ties into another issue that pops up at that time too is liquidity. How
Yeah.
are you invested? Are you locked into GICs or are you in, some sort of private equity investment? It's great to be able to pass those types of investments on. That's where having a financial plan that looks forward, it really does give you a lot more visibility into how much can I gift today. Down payment for a house, a lot of parents will seek to have that as a big goal as their children move out into the world. Knowing exactly what that amount is, what you're comfortable with, how your liquidity is set up, really becomes an important part of that.
Yeah, there's a couple of ways to address that. And to your point, Eric, I'm going to use the GIC issue because a lot of older people go into the bank. They don't want to risk any of their money, which is understandable, and they want the safest investment possible, so they put in the GICs. They also want the best rate available, which means it's a non-redeemable GIC. And the banker will say, and they're not wrong in saying this, the banker will say, They are illiquid with the exception of death or financial stress. But I've also worked for the banks and I've worked near the GIC department where I've literally seen estates take over 2 years to settle because those GICs could not or would not be broken for whatever reason. Right. So that's a good point on the liquidity side. So if you are going to look at investing in GICs, if that's your comfort, then at the very least consider it a cashable GIC. So that way you do have that form of liquidity. If they are non-registered GICs, I would strongly encourage you to do it through a life insurance company because a non-registered GIC that you do at the bank or the credit union or online, those are going to still go through the estate. If you're single owner, you can't name a beneficiary on the non-registered GICs through a bank or a credit union. But you can if it's a life insurance company's GIC. They might not be called GIC, they might be called like a GIA or a GIO, but they're essentially the same thing. But the difference is they're underwritten through the Insurance Act, which allows you to name a beneficiary on those GICs. Technically, it's a segregated fund contract. And no, you're not paying the management fees. That's a segregated fund portfolio. I'm talking about GIC specifically. The rates are very comparable to what you see at the banks. And literally, all that money would bypass the estate, go directly to your beneficiaries, and it could simplify the executor's role. So if you are an executor, you've been asked to be an executor and you've taken on that responsibility, you've agreed to take on the responsibility, and you notice that the person who's assigned you as the executor has a bunch of GICs at the bank that are non-registered, start looking at something that's available through the insurance company because, as I mentioned, that's going to make your job a lot easier once you're ready to start settling the estate. The other way of having liquidity is insurance. Having life insurance, that's immediate liquidity. So a lot of people think about needing insurance while they're alive and they have a young family to pay off the mortgage and whatever else. Life insurance is a great estate planning tool. So if we use, for example, the house that's going through probate over a 9-month period, if there's a life insurance policy and proceeds that get paid out, you can use that money now. You have the immediate liquidity to cover off some of those expenses until you're able to eventually put the house up for sale. And again, who knows how long it'll take that home to sell anyway, right? So liquidity, you're absolutely right, Eric. I agree with you there. And a couple of ways you can do that, again, is cashable GICs, preferably through an insurance company, and having life insurance as part of your estate plan.
Yeah, and it's a good point to highlight that any of these products, whether it's life insurance, GICs through an insurance company, or segregated funds, they all bypass probate as well. You save yourself 1.5%, yeah, but you also get your money right away.
Yeah, you're right.
And to kind of just tie that one up and lead into what sophisticated families do differently, one thing I do want to point out, it was one of the defining moments in my youth that led me to really understand investing. When my grandparents passed away, they left GICs for all of us. They were all
Right.
split up. And I remember not understanding it at first, and my dad explained it to me. It was back in the days when rates were like 10%. It was a small amount, like $1,000. But I thought to myself, if I had $100,000 to invest right now, I could earn more than I had ever imagined I could earn. So that is one thing sophisticated families do is they do plan to pass on investments, whether it's a GIC, whether it's private equity, whether it's securities that are traded in the public market. Passing that on is a significant way to pass on a legacy of planning ahead, of thinking, what can an asset do for me if I invest it? It really is a good way to teach that principle.
Yeah.
Denis, with your tax and estate planning background, what are the really important cases that estate freezes help out in those scenarios?
Well, it's an estate freeze is really used a lot by business owners when they freeze their shares. They want all the future growth to go to their beneficiaries, which is usually their kids, can be done directly or indirectly through a family trust. And there's a lot of ways you could set it up where you could still hold control of the company, but basically all growth is going to the kids. And there's decisions on whether you cash in or pay the taxes immediately. That could be postponed or can be paid right away as well as a business owner. So it gives you flexibility while alive and kids get the ownership right away.
Family trust is another one. Now, where family trust is important, again, is in controlling the distribution. So you can basically set up a trust, and in the trust, you can outline who gets what and when, right? But remember, when you set up a trust, it's almost like having a corporation. A trust has its own tax reporting, and that's becomes expensive. It's not going to be $200 that you can get done at H&R Block. Like it's $1,500 to $2,000 a year on the tax reporting. There are taxes that the trust may or may not have to pay. There are taxes that the beneficiaries may or may not have to pay. A lot of times I will have people say, well, I heard about this trust on TikTok and maybe I should do that. Again, maybe, but it all depends on your financial situation, and understand that there's all these other costs associated with it.
And legal setup costs are quite high.
Le- Yeah, legal, accounting, and you're paying the highest tax rate within the trust for the most part.
It's 50%, right?
Yeah,
Yeah.
yeah. So yes, it's a good instrument depending on what you need, but it is expensive and can get expensive if you have your assets in there.
And then you have to wind up the trust a year 21 as well. There's a 21-year rule as well. That
Yeah,
all depends.
everything is
Yeah.
again deemed to be sold. You're paying all the capital. Sometimes they continue, but every 21 years, everything is gonna have to pay full gains on it. You can't keep it hidden forever.
Right. So again, when you are out there on social media and you're seeing all these solutions, it's good to question if it's right for you. Like, we're not saying you shouldn't question them, absolutely, but keep in mind that it's not necessarily for everybody, and we'll help you figure that out. Corporate-owned life insurance, I do a lot of this. That helps with liquidity for the corporation as well. Holding companies, that's another way of doing some estate planning, depending again on your corporate structure. So these are some things that, if you are looking for more information to see if it's applicable to you, let us know, and we'd be more than happy to, once again, here in Ontario, connect you with Sonia. Eric, you have someone in Alberta you could connect clients with. Okay, let's get to the final segment, which is the conversation guide, what to say without making it weird. So I think the first, and that's tough, right? But
Yeah.
I think really the first one, which I like here, is start with the context, not the numbers. Let's not talk about numbers. Let's start off with, here's what we're trying to accomplish as a family. What is it we're trying to accomplish? Family cottages is a perfect example. I've dealt with situations where there might be a family cottage and you might have 3 siblings. One of them absolutely wants the cottage. They grew up there. They loved it. The other one might be like, hated going to the cottage as a kid. I don't want that thing whatsoever. The third one might be out of country. So it's really about what's the goal here for mom and dad, mom and or dad, and vice versa as well, and ultimately for the family, for the kids. Like, sometimes it's, you know what, I really want the cottage. I love growing up there. I have my kids. I want them to have the same experiences that I did as a child. So then the issue is, well, how are we going to make that happen, and how is it going to be fair for everyone? And I think, Denis, you mentioned even before, it doesn't have to be equally split as well. If it's not, one might feel kind of gypped off compared to the others. But there's nothing in the law that says that if you have assets and you can distribute them, they have to be distributed equally amongst your beneficiaries.
Yeah, and I think people forget the fact, oh, I got the cottage. Well, you also got the taxes, you got the maintenance, you got everything else that goes with home ownership. That's why it's important to know that if somebody does not use it, do you think they want to pay taxes and maintenance costs, replace that roof? No.
No.
So that's why it needs to be clearly discussed who's going to get it and can they afford to pay all that? That's the other part.
Yeah, and not only that, can they afford to pay the capital gain tax on it? Because once that parent passes away, if there's no surviving spouse, that's triggering a capital gain. And I've known family cottages where original purchase price is like $50,000, now valued over $1 million. That's a $950,000 capital gain, right?
Yeah, and a lot of cases, whether it's the primary residence or the cottage, sometimes there's very little assets, and the biggest asset is the house or the cottage.
Yeah.
So you got to be careful on that as well. As you say, you got a lot of fees to pay. Now you're going to take that out of pocket. May be forced to be sold.
Yeah.
You may be forced to sell it.
Eric, you were going to say something?
Yeah, I was just going to mention that, again, when it comes to the equality equation, having the conversation, if a will is unfair at all, it makes it very easy for people to come and challenge. Having the conversation while you're alive or with your parents while they're alive really gives an opportunity for everyone to understand why the parents want it a certain way. And if you can get that buy-in before it's too late to really understand what it is they actually wanted, that just becomes a potential disaster that can end up causing so much strife in the family. And so it really comes to our next point is who needs to be in the room?
Yeah.
Who are the people that need to be there? And so, I mean, the obvious one would be parents, the kids, whoever's affected, executor, who's the power of attorney, who's
Yep.
going to be making the medical decisions if dementia or things like that become an issue.
Yeah.
And then sometimes the advisors, the people who are going to be helping, whether that's your lawyer, your accountant, or your financial advisor who maintains the assets that are outside of the home or the cottage. And then really I think the next big issue is timing.
Mm-hmm.
When do you have this conversation? Do
Right.
you have it before your retirement, after your retirement? When is your retirement? That's part of the conversation in itself is when are you going to trigger those things? When are you going to sell a business if the kids are involved, if the kids aren't involved? When are you going to review your executor? Who's going to be the power of attorney? And like you said, Jim, I think you made a really good point that in 20 years, the person you choose for that, for many, many really good reasons, might make that person not the right person for it anymore. And having those conversations become, and then real estate, do you sell the cottage if nobody wants the cottage? Well, at what point do you sell the cottage, or do you hang on and let it dilapidate for 20 years while the parents are struggling with things like dementia? There's a lot of really important timing questions
Mm-hmm.
that need to be discussed through that whole process.
It has to be done now. You can't wait. There's accidents, there's illnesses. How quickly somebody could go with a bad cancer diagnosis or an
Mm-hmm.
accident.
Yep.
You need to do it now and update as needed. It gets even more complicated with blended families. You got a new spouse, you got kids from another marriage, and depending how long you've had the new spouse and the stepkids, they're part of the package as well. So now an update when needed afterwards. So I think the conversation needs to happen now.
Yeah, and a couple of points before I forget. Just by placing your assets in joint ownership, that's not estate planning. A lot of those rules have changed as well, so keep that in mind because I do know a lot of bankers keep recommending to their clients, "Oh, just put your kid on as a joint owner, and you'll bypass the estate." That's not always the case anymore. That changed in 2017. The second one is not do it using a will kit. Like hire a lawyer because they're going to walk you through all these different scenarios and have you really think about what you ultimately want done in terms of distributing those assets and some of the concerns. So when I go back to who needs to be in the room, Eric, I know with us, Sonia handles a lot of the wills and powers of attorneys for our clients. A lot of times she brings me into the conversation to say, well, what assets do you currently manage? And out of those assets, which do we have to identify in the will? And which do we not have to worry about because it's either in a segregated fund or it's a registered account with a beneficiary on there. So we're communicating on a regular basis on behalf of those clients. A lot of times the advisor isn't brought in, the lawyer doesn't make that suggestion. It's almost like you have the couple trying to put a plan together. They meet with the lawyer. They have their kind of structure and how they're going to handle things, but then the advisor might do things a little bit differently, and no one's really talking to each other. And at the end of the day, it still might be a failed estate plan. So try to have all the important people in that room to have the conversation. But we'll make it easier if you decide to work with Sonia here in Ontario. What's Ryan writing here? 100% of people in the cemetery believe that they had more time to have these conversations. And what will it cost your family if you decide to save on writing your will? Absolutely. So really good points, Ryan. So here's a big one. Location of documents. I don't know how many people have had probating delayed because they can't find the will. And I almost swore there. But just like let your executor know, like at least give your executor a copy of the will. If you want it sealed so they don't see it because they might happen to be a family member, at least tell them where they can find that will. Because I don't know how many times I've heard clients say, you know what, mom passed away or dad passed away, and I don't know where the will is, and I've gone in the house and I've searched up and down and everywhere and can't find anything. Let them know, please. It just makes it so much easier.
Rise says it makes a great Easter egg hunt.
Yeah, no, it doesn't. Equal versus fair. Sometimes where this really comes into play, I know we've talked about family cottage, but also in businesses. Sometimes you might have one of the kids who's been working in the business, invested in the business, blood, sweat, and tears in the business. Does it make sense to then all of a sudden split that entire business equally amongst all the kids, where maybe one of them has really invested a lot of their time in that business? I don't know, right? So you want to kind of weigh what's equal and fair, and know the complexities between a business, the properties, insurance. Like, these are very important to understand. Let's see, power of attorney gap. Only 32% have it. A third of the population has a power of attorney. Do you know what happens if you cannot make your own financial decisions or health decisions and you didn't write it down? You know who ultimately decides what happens to you in Ontario? The government. I don't want the government to decide what happens to me, right? So go out there and get yourself a power of attorney, because I know there's this whole feeling of it'll never happen to me. Well, you know what? 7 years ago, I didn't think I was going to go in for open heart surgery. That was very unexpected, right? Thank God I had my affairs in order. The first thing I did when I found out I needed open heart surgery was I pulled the wills and the powers of attorneys out, put it on my desk so my wife didn't have to try to search for it. She knew where it was in the house. I just made it easier. Here are the life insurance policies. Here's a will. Here's the power of attorney, just in case, right? So please just get it done. Don't put that off, because the government will decide. We just had a family friend, wasn't feeling well, all of a sudden went to see the doctor. Doctor turned around and said, "You're literally having advanced heart failure. Go to the hospital." He wasn't thinking that he was going to be going to the hospital for advanced heart failure when he woke up that morning, right? So again, put your affairs in order. And thankfully, he had his affairs in order. He's alive, thank God, right? But just please do it. Well, what's Ryan saying here? Note how our TVH process allows us to make it easy for clients, families, and executors to know where everything is. Life made easy with TVH. I'm starting to think, guys, that we shouldn't actually have Ryan as part of our live recordings anymore. That he could just
keep us notes.
Give us this live commentary. So Eric, sorry, you're saying something?
His comment is really, really important, though, because at TVH, it is nice because one of us knows, then we can make sure the whole team knows, and all of that execution can be integrated very well. But even if you're not with a team like we are, make sure your lawyer knows who your accountant is, who your accountant knows the executor, so he knows who to call. For the longest time over my career in this industry, I've done something called an estate guide, and it's really just a spreadsheet that has room for people to fill out all of the information of who's important, whether that's family members they want notified, friends they want notified, but also their accountant, their lawyer, the phone numbers, their addresses, because the executor, who likely be someone who's grieving as well, has this task put on them just to make it easy. They know who all needs to be contacted. They can find all of the assets. They can find all of that. People want to be free to go through the grieving process. And so if I'm gone tomorrow, I want to make sure that they have everything they need so that they don't have to worry about the stresses of all the other things. They can just worry about the personal time, the seeing family, seeing friends, whatever that process entails, that the administrative isn't overpowering the feelings that you feel when you go through that. And so ultimately, death is something we cannot avoid. What we can avoid is the disorganization, the discord, the stress and the strain of someone trying to pick up the pieces of a life that they didn't understand, whether it's dementia or whether it's death. Having those conversations, as hard as they are, before you get to the point where they're infinitely harder, I think is the key. And that's what I'd like people to walk away with today, is to know that it might be a tough discussion, but it's an easier discussion in every respect than waiting till tomorrow or waiting till a year from now or 10 years from now, when those discussions are infinitely more difficult.
Right. So by having your affairs in order, writing down again, putting a will and power of attorney, all the things in place, the taxes will be predictable, and family conflict potentially, or most likely, is also preventable. Avoiding the conversation doesn't protect your family, it exposes them. So don't sweep it under the rug. Have the conversation, because it will save a lot of issues for the families once you pass away. And I do know I have the rare client who says, "I don't care at that point because I'm dead anyway." Most people don't feel that way. They don't want their family to be dealing with it. I don't know how many times that I've actually had a sibling or a child of a parent who had passed away, that they had to settle the estate, where then they come to me saying, "I've put this off for too long. I saw how difficult this was with mom or dad and dealing with their estate. I need to make sure that I do this the right way, but my kids don't have to deal with this. So part of it is experience and learning. So, call to action. First thing, confirm you actually have a will and a power of attorney. Find it, blow the dust off of it, do a review of it. And if you don't have one, let us know. Reach out to us at financial@tvhgroup.ca, and I will connect you to Sonia to help you with the process and her team as well. List all your assets and how they're owned, personal versus corporate. Even here for corporate owners, sometimes it's actually beneficial to have a secondary will or a corporate will to help bypass the estate and probating. That's a little bit more advanced planning. But some people who have corporations think, oh, one single will is enough. No, sometimes you do need a secondary will to address the corporate assets. So keep that in mind. Book a 60-minute family clarity meeting with or without advisors. So you can start off without the advisors just to start to open the conversation up. And then from there, decide if you want to have a follow-up meeting and which advisor should be in the room for that. And then finally, if complexity exists, business, real estate, $1 million plus in assets, get a coordinated plan. So I think it's stressing here. If your assets are going to be over $1 million, really start to focus on this. I think you should probably consider that even if it's under $1 million, but it's something you really need to start considering. So when we look at TVH, we sit at the intersection of planning, investing, insurance, and lending because these decisions don't happen in isolation. Most people make them in isolation. That's where there's the issue. We don't, and this is why we encourage you to work with us at TVH Group. So, guys, I'm going to be signing off now. Eric, how can people find us on social media?
On Spotify, YouTube, TikTok, Instagram, LinkedIn.
X, Twitter, all those
Oh yeah,
places.
X, Twitter, and then website, tvhgroup.ca. Phone numbers are all on there in our email.
Absolutely. And we do send this out as a podcast. We do send it out as a blog post. So if you don't want to listen or look at our faces, you can read about what we've talked about today. But again, I encourage anyone, if you have any follow-up questions, you'd like to set up a time with any one of us, reach out to us, financial@tvhgroup.ca, or call us at 647-727-4668. Here's Ryan again, the ghost of Ryan. When it comes to family money, the real inheritance is a box of mystery paperwork, a surprise tax bill, and enough drama to keep the Thanksgiving interesting for years. Thanks, Ryan, for that. Eric, we do have a recording in 2 weeks' time, a live webinar. Who are we meeting with and interviewing, and what are we talking about?
We're meeting with New Look, and we're talking about their infrastructure and industrial services fund. Operates in a code-regulated industry. I love everything about how the revenue curves are in that industry. Yeah, we'll be getting into all kinds of details. So tune in if you're interested.
Yeah, so if you want to kind of be kept up to date on our upcoming recordings, go to the TVH Group or TVH Financial website, and there will be an option for you to sign up for our blog post or newsletter, and we send out the invitation the week before the recording. So, guys, once again, thanks for your time. Looking forward to seeing you again. Take care.
Bye.